Welcome to Miranda Warnings Roundtable, discussing legal issues and current events. I'm joined on the roundtable by Liz Benjamin and Professor Vin Bonventry. Liz is the managing director at Marathon Strategies, a public relations and communications firm, and former host of Capital Tonight, a political and policy show focusing on New York State politics. And Professor Vin Bonventry, distinguished professor of law at Albany Law School and publisher of the New York Court Watcher, devoted to commenting on the U.S. Supreme Court and the New York State Court of Appeals. This week on Miranda Warnings Roundtable, we're going to provide a legislative recap of the New York State legislative session. This has been one of the most successful legislative sessions for the New York State Bar Association in recent history. Several priorities of the New York State Bar Association were passed by both houses of the legislature during the budget session. The New York State Bar Association's proposal regarding the increase in the fees for assigned counsel, 18B, was passed by both houses of the legislature, raising the rate for 18B assigned counsel to $158 per hour from the former $90, the first increase in approximately 20 years. And during this last week, there were a couple of priorities of the New York State Bar Association, one including the repeal of Judiciary Law, Section 470, which makes it now easier for lawyers licensed to practice in New York to actually practice in New York. Section 470 of the Judiciary Law is repealed, and that had required a physical office space requirement. We'll talk a little bit about that, and we'll also talk about Clean Slate. A Clean Slate legislation has passed that the New York State Bar Association has been advocating for many years. And there's a couple of others regarding the CPLR and immigration rights that we can talk about. But let me start it off with Liz. Liz, what's your big picture assessment of the legislative session this year?
It was a big stinker.
You didn't like it? You didn't like it? I just gave a big buildup of how great it was.
I mean, look, no. Okay, all right.
You just gave it a big buildup. David's bubble for crying out loud.
Well, I mean, to be fair, David is looking at it through the lens of the State Bar Association, and there were some significant wins for the State Bar Association. The State Bar Association, and it's great for bar members and access to justice, particularly when it comes to 18B. But like overall, the budget was a month late, which cut into their ability to have time to do anything of significance after the fact. Clean Slate was modified. I mean, it's still a significant, win. The housing compact, nowhere. Didn't get over the hump. The Assembly now says that they're coming back in a couple of weeks. So clearly they didn't get everything that they wanted. The governor lost on Hector LaSalle, which was a big deal. It feels like a million years ago, but it was not too terribly long ago. And maybe not of so much importance or interest to NYSPA members, but she also lost on her NYPA appointee, Justin Driscoll. So, she didn't have a great session. Am I going to say that New Yorkers' lives are measurably changed for the better as a result of the work that the legislature and the governor did this year? Not entirely sure about that.
Wow.
Sorry, David. Sorry. But I mean, like, I am not trying to belittle the significance of the achievements that you were able to realize on behalf of NYSPA membership. The issue related to 470 is big, very big. And of course, like also 18B, well, let's talk about the funding. That's a little bit of a wrinkle there. So I think we have some things that we can talk about.
Right. 18B, of course, it increased the rate from 90 to 158. The New York State Bar Association actually still remains involved in a lawsuit on a couple of issues that need to be addressed with respect to that. One is a mechanism for an increase on a year-to-year basis so that we don't have to keep fighting over this. That's still part of the lawsuit. We did ask that the rate be comparable to the federal rate, which is 164, so it's not quite exactly where we had hoped it would be. And also, we believe that it should be, the New York State Bar Association, at least policy is that should be a state funded increase and not a unfunded mandate to the municipalities.
Yeah, I mean, look, and I guess my role for today is skunk at the garden party. So I'll just.
Is that only today? What were you the other days?
Wow. It's getting cold in here, man. I don't know.
Well, all right. Well, let's hear.
Hold on. So just from a municipal government standpoint, I mean, another thing that happened that's not so great for municipal governments, well, I mean, ostensibly it might be, is it depends on your political persuasion, I guess. So they also passed legislation that would move a number of local elections to coincide with the calendar of presidential and congressional, which of course, as we know, is good for Democrats because we have a Democrat-dominated state and you have turnout actually that goes up on those elections. Traditionally on those cycles, and the so-called off cycles are good for Republicans because we have fewer Republicans enrolled in New York, and then the Republicans manage to retain their toehold at the local level. From a financial standpoint, that actually makes more sense because the fewer elections that you have to run would actually be beneficial. But I think that the local governments were not thrilled about that particular development.
Vin, what do you think about the legislative session? Anything that jumped out at you as particularly significant, or something that you thought maybe was a missed opportunity?
Yeah, well, I mean, obviously the governor is not getting everything that she wants. I mean, even though the Democrats have a supermajority in the houses, I mean, the Democrats are split between, the progressives and the more moderate members of that party. So, and she's obviously a member of the moderate wing, the Democratic Party. So she's not going to get everything that she wants, because just like with Hector LaSalle, her nominee for chief judge, because the progressives oppose many of what she wants, and she's not exactly in favor of much of what the progressive want. But for example, on bail reform, I mean, a compromise was reached. And although there are some, claiming that, oh, my God, what we did with bail reform initially was the best thing ever. I mean, give me a break. Some people are just so damn ideologically blind. I mean, there needed to be refinements. There are those on both sides that were, claiming the sky is going to fall if they don't get exactly what they want. But, they managed to come up with a compromise. One thing I hope that is done when the legislature apparently comes back for this extended session of this, who knows what.
Well,
what they
Senate,
call it.
The Senate has adjourned, right? The Assembly is coming back, right?
Yeah, it's just the Assembly that's coming back?
I believe so, yes.
Well, that's unfortunate because I don't think that anything yet was done with the with wrongful conviction, the Wrongful Conviction Act, which I think, and that, I mean, when Liz says, there are certain things that were done that's good for the bar and good for lawyers, but one of the things that I think that's very good for the state is if we had some legislation on wrongful convictions, because the Court of Appeals has been absolutely abominable on ensuring that people who are wrongfully convicted end up being exonerated and end up having their convictions thrown out. There's that absolutely notorious case of just a few years ago with, of course, now Chief Judge Rowan Wilson in dissent in that case, that's People versus Tiger, in which the Court of Appeals knew that the woman was innocent. But because she had pled guilty, right, to avoid a possible 7-year sentence, because she pled guilty, the Court of Appeals says, well, we can't, undo her conviction. Well, of course they could have undone her conviction on basic due process grounds. But, they said, well, the statute itself doesn't give us the authority. Well, basic constitutional due process does. And so the Wrongful Conviction Act apparently is going to provide that wrongful convictions may be overturned, even if there is no DNA evidence, and even if the individual had originally pled guilty. Because as we know, people plead guilty all the time for all kinds of reasons, and it's not necessarily because they are guilty. So I don't know what's going to happen with that, but I gather if the Senate is not coming back, then I guess nothing's going to happen with that bill.
Well, I think the Assembly is coming back to address some issues that the Senate already addressed, right? And I think it's a little bit of a cleanup. Liz, do you have any more insight on what the Assembly is going to pick up when they come back? I think within the next 2 weeks.
One of these last minute wrinkles was a bill that enabled the governor to enter into a casino compact renewal with the Seneca Nation. And there are reports out today, as we're recording this, that deal also potentially includes the siting of a casino in downtown Rochester, which I think that the Rochester delegation was like, whoa, we did not negotiate this. We don't know anything about this. And why I don't know that we approve of this. And of course, the Del Lago folks are not terribly far away. And so they're not happy about that. So that passed the Senate, but did not pass the Assembly. I think that the no vote there was Senator Cooney, who is of the Rochester delegation. And that's one big outstanding item that the Assembly had not addressed.
I want to touch on something that Liz mentioned as something that was not a positive out of this session. And that was the housing deal that Governor Hochul had made as kind of a centerpiece of the legislative session that actually did not get passed. And Liz, maybe you can give us some insight on how that deal kind of fell apart.
Where would you like me to start?
Well, first of all, what was the governor proposing and why didn't it work?
So broadly, the governor put forward a very far-reaching housing compact that would have resulted in the development of 800,000 new homes over a period of a decade. The state is facing an affordable housing crisis, not only in New York City, but also statewide. The difference outside of the city is that a lot of the housing stock that we do have is aging and not up to par in terms of being habitable, right? And it costs a lot to rehab a old building. So there's that. We also have, a demand with the migrant crisis that is growing, a homelessness crisis. So we've got a lot of things that are problematic. So the governor puts forward this housing compact. It created targets for localities, and it broadly potentially usurped their power and control, creating specific areas like along transportation routes, for example, where you would have to develop, and targets that you would have to develop, and rezoning that you would have to put in place in order to facilitate development. All of these things rubbed a lot of local communities the wrong way. Let us give them the benefit of the doubt and say that they didn't like it because they didn't like the idea of not having their own, being able to control their own destiny, and not because they didn't like the type of people that would have come along with the housing if they were forced to build said housing. So it failed, fairly spectacularly, although I would say there were some, like the suburbs were particularly potent in their opposition, north of New York City in the Hudson Valley and on Long Island. The governor, put forward this bill, and it was very far reaching, but she didn't do a lot of legwork prior to the fact in terms of building a coalition necessary to get this over the finish line, which was sort of the same rap that some people said was the problem when it came to LaSalle. So, she hadn't done the legwork necessary to build. When you put forward something, very unpopular, you really should try and socialize it with people who would, likely be opposing it, and maybe do a deal with them. At the end, there was at the very end of the session, there was a possibility of resurrecting it. That was in the budget and it failed, right? So then there was a possibility of resurrecting it. But again, the budget was a month late and we didn't have a whole heck of a lot of time to try and do anything. And in the 11th hour, there was this possibility of linking good cause eviction with 421A, with the renewal of the tax break that goes to for-profit developers to encourage them or incentivize them to build affordable housing, which is very controversial, and housing and tenant advocates don't like it. So it didn't get over the finish line at the end of the day.
So you said there was at least some movement to try to develop a compromise. You think this is something, this issue is not going to go away? Is this something that we're going to have, we might be able to regroup and
we
try
have
to address again in
the crisis
the next
isn't going
session?
away.
Right.
The
So
need for housing isn't going away. The vulnerable populations who are continuing to languish and having ever more increasing needs isn't going away. So all of that is going to continue. And, we sort of wasted another session with a lack of an agreement. I'm not saying one way or another we should have done whatever X or Y, but we don't have a deal and we don't have a plan.
And there was no final decision with regard to strengthening the good cause eviction rules, protecting the tenants even more. I mean, that's a real dicey one. Well, so many of these are really dicey, and there's strong arguments on both sides. On the one hand, it's obviously a very, very legitimate interest in trying to prevent landlords from, evicting tenants simply because the landlords are greedy and they just want to make more money. But on the other hand, the extent to which tenants are given more protection also means that there are some tenants who are simply derelict, and it becomes extremely difficult for the landlords to evict them and get a tenant that actually pays the bills or doesn't destroy the apartment. So, I mean, there really are strong interests on both sides, as there are with so many of these things. I mean, the bail reform thing is one of those things that, if you listen to the two sides, they claim it's so clear it ought to be this way or so clear it ought to be that way. But these things are tough. These things are really, really tough. I mean, what's the purpose for bail? And ought there be some provision to allow the judges to exercise greater discretion than they already have to keep somebody either in pretrial detention or to levy a bail requirement upon them or not? Or is this really just allowing the judges to continue what the system already does, which is to disadvantage minorities, right? Which is, the minorities and the poor. So, I mean, these issues are tough. And I think it's kind of crazy. I mean, Pollyannish to think that, even a legislature that's trying to do the right thing can very easily come to agreement on these issues.
You mentioned that during the session, we've talked about it quite a bit, the issue of the Court of Appeals, where the first nomination of presiding Judge LaSalle was not successful, but the second one of now Chief Judge Rowan Wilson and now Associate Judge Caitlin Halligan was successful. And so the governor and the legislature, I believe, seem to have put that behind them and are moving forward on for new items. There was, I think it's worth mentioning, there were 11 new Court of Claims judges that just came out at the end of this session. And I know Liz,
including the nation's first ever sitting trans judge, we believe.
Right. That was kind of the news out of those 11, the first transgender judge that's or that was nominated. So that's certainly important. And there was other legislation that didn't make it through that the New York State Bar Association had advocated for. One was to ensure that town and village justices are lawyers. And currently you can have lay people as town and village justices. That, I believe, passed the Senate, did not make it through the Senate, but it also garnered the support of the Office of Court Administration, which was new. And that particular piece of legislation, although it didn't get through the finish line this year, is something that I think we can look for in future sessions.
I mean, but is that really a lawyer protectionist measure? I mean, do you really
not
need
at all? Not at all.
Do you
Not
really need a lawyer for all these kinds of issues that come before these town justices? We know there are abuses, but there are abuses by lawyers who are judges as well.
You should read the New York Times.
I read it.
Extensive investigative.
By Bill Glaberson. Oh, yeah.
Yeah. I hope it lit your eyebrows on fire, because that was really egregious.
Well, of course it was.
Okay, well, I would argue based on that, and just based on that, I mean, look, OCA, like the Office of, it's Tim Beckian's organization, right? The judicial, what are they called? There's policing of lawyers and policing of judges.
Yeah.
Right.
However, at the local level, things get very
Yeah.
dicey very quickly. And, that's where a lot of people, that's where, I don't want to say the majority, but a lot of people intersect with the legal system
Right.
at the local level, and they deserve to have quality representation on the bench.
But wait a minute, quality, wisdom, equity are not monopolized by lawyers. In fact, many lawyers I know totally lack those, including judges lack those.
That may be the case.
You got to hang around with a better group of people.
But let's just be clear: the current system is not generating that kind of representation.
Of course.
For the public. So something should change. The NYSPA has said, in all their wisdom, perhaps, and this law and this bill, perhaps it would be, effective if you had people who actually knew the law, who were sitting on the bench. Like, kind of seems logical. But I'm not suggesting that's the only way, but that's the only thing I know of that has been put forth to actually fix the problem.
Agree with you totally. Yeah, agree with you totally. It would be an improvement, but there are other ways we could improve the system.
Such as what?
What? For example, giving training to those who are going to be
course.
town justices, some basic training.
They do that. I'm sure that they do that.
Yeah, it really works well, apparently.
Well, right. Yeah, that's
We're going to see if we can get Vin to give one of his lectures. I think that would be an improvement. There's one other. I want to move off the legislature just for a moment. I want to talk about a case that's working its way through the New York appellate system, and it involves redistricting. This is a case that we talked about a lot last year. It had tremendous impact, both statewide and nationally, where the Court of Appeals last year around this time found that the redistricting map was unconstitutional, and they had a new map drawn via the court system. And now there's a case pending that says, okay, that was the map for last year, but they're saying there should be a new map drawn under the constitutional process. And the argument on the other side is, well, no, the map that was drawn last year now lasts for 10 years. It went to the trial court. The trial court said, no, it lasts for 10 years. And now it's currently at the Appellate Division 3rd Department. They had arguments. They haven't had a decision yet. But either way, that's going to go back up to the Court of Appeals. And we'll have the Court of Appeals, a new Court of Appeals now issuing or looking at redistricting again. Vin, what are your thoughts on this case and how it might end up?
Well, I think it is a different case.
Right.
In fact, the majority opinion by former Chief Judge Janet DiFiore made a point of saying, at this juncture, this is what we do. We send it back to this trial judge who then gets this statistician, and then they put together this.
And they did, right? And they did, and had an impact on the state last year and the election last year, and it impacted our congressional seats. And so now they're back saying, well, do we have to keep this for the next 10 years? Or can we now go through the process all over again?
Well, I think the chief judge was making it clear that what she ordered, the remedy she ordered, was something that needed to be done because it was an emergency situation. It's something that had to be done urgently, which is completely the opposite of, well, now we have time, maybe we can do it the right way. The other thing is, I think it's really unconstitutional to have sent it back to some trial judge and have some trial judge put this darn thing together. Remember, it was a 4-3 decision. You had 3 pretty darn strong dissenting opinions. And now one of the dissenters, of course, is chief judge, right? And now you also have Caitlin Halligan, and we don't know how she's going to vote. But I'm not convinced that the other judges who were in the majority are necessarily going to say that what was done in the first case right, is what prevails over the next, I don't know, 9 or 10 years. I do think that this is a different case.
Right. So it's
Does that mean you agree with me when you say right?
Open season. It's open
I think,
season,
you know
right?
what, that's
for all
like a
of them.
trope of his. He sort of just says right when he means like right, like, and then continues.
So he doesn't agree with me.
He's not agreeing with you. No, it's
I
a
know you
verbal
never
trope.
do, but I think David does every once in a while.
I'm just trying to keep the dialogue going. I don't want to
He's
put my
just moving
I don't want to
things
put my
along.
thumb on this
Yeah,
thumb on my
no.
scale, right?
Just,
I was
so-
just
I
trying
just want to be clear. He's not agreeing with Vin.
I'm not disagreeing. I'm not agreeing.
You're such a lawyer.
You know, we didn't talk about the lobbying, right?
Oh yeah.
The
Sure,
lobbying. What happened with that?
Lobbying.
Although I think that what is being proposed may actually be unconstitutional.
Wait, whoa, back up. What are we talking about?
We're talking about extension of this lobbying act, which requires the identification of who it is that's paying the lobbyists.
Mhm.
Well, 2 years ago, the United States Supreme Court in the Americans for Prosperity decision ruled unconstitutional a California law that required the identification of donors, right?
Mhm.
And that was to nonprofits, let alone donors to
I remember that.
political organizations. I mean, you talk about a First Amendment freedom.
Wait, can I go? Is this at all related to probably not at all, but this battle that Congressman Santos is having related to the revelation of the identification of his suretors?
Well, in New York, it actually has to do with lobbying groups who came out in favor of Hector LaSalle. And of course, the progressives are very upset that there were these lobbying groups supporting Hector LaSalle. And they want to know who the heck was supporting them, financially supporting them. And I guess that the proposal is to require that the donors, right, those who are financially supporting these lobbyist groups, whether it's to support a judge who's been nominated or anybody else in government, that the identities be disclosed. But I'm pretty sure the United States Supreme Court would say that that's a violation of First Amendment freedom of expression, First Amendment freedom of expressive association. Well, the liberals didn't like any kinds of requirement to identify members and contributors when it involved the NAACP back in the 50s, and Alabama wanted to know, who are all these members? Who's supporting the NAACP? The Supreme Court, of course, at that time threw it out, said you can't require that. And then the Supreme Court used that case to throw out the California requirement that donators to nonprofits be identified. So if that's what this lobbying act is going to require, I'm sure there's going to be challenges, and I would imagine the Supreme Court's going to throw it out.
Mhm.
All right. Well, Vin, you thank you for bringing something to the table here. We'll
Wait. You didn't say right.
I said thank you.
Yeah, but
He
you
said
didn't say
thank you.
right.
Because
You want
he's
me to
not
say
sure
right?
where he stands on this.
Liz just told me I have a trope. I'm trying to. I'm going to go look up what trope is, and then I'm gonna try to fix it.
Yeah.
So you're not right. You've raised a good issue for all of us to be enlightened by, as you always do. Liz was kind enough to point out that I have a trope.
God, you are so sensitive. You people are sensitive.
I'm not sensitive in the slightest. You make fun of me all the time.
Too.
I'm
not
fine
making
with it.
Fun of you. I'm just pointing out realities. That's just what I do.
Well, I love the reality that both of you bring to this roundtable. We covered a lot of ground.
Yeah.
You guys are both great. I appreciate all the insights that you provided, and I look forward to following up on some of these issues with you as we go forward. So, Vin and Liz, thank you very much for being on Miranda Warnings Roundtable and enlightening us.
Thank you for having me. I love this.
This has been Miranda Warnings, a New York State Bar Association podcast. You have the right to subscribe, rate, and review.